Ladies and gentlemen, welcome to the webinar. This is our first 30 minutes medical and health law series. Today's topic is 5 often overlooked medical contract clauses. Our presenter is attorney Eric Boughman. If during the presentation you have a question, you can type it into the questions section of the webinar interface. Similarly, you will find a copy of today's presentation and our free brochure in the handout section of the webinar interface. And now, without further ado, let's hand it over to Eric. Go ahead, Eric.
All right, good afternoon, everybody. Thank you for joining us in what is the first of what we're looking forward to doing routinely throughout the next year is a series that we're calling the First 30 Minutes. And what this is going to cover is questions that often come up in initial consultations when we meet with clients about various topics. It'll be a lot of basic information that we see as lawyers all of the time, particularly when dealing with issues representing our healthcare provider clients. We'll cover some other issues throughout the year. We'll probably touch on some buy-sell arrangements in ownership agreements that will pertain to medical practices and other businesses as well. So if you're not in the medical profession, this still will hopefully be helpful to you. If you are, then you will see some provisions, sometimes that are unique to the medical industry, and sometimes that are more general. This first one, we're going to talk about just 5, we've titled it 5 often overlooked medical contract clauses. Some of these are particular to healthcare, and some of these are things that we see on a routine basis industry-wide. So again, hopefully it's helpful for you today. We're going to cover some other points over the next 25 minutes or half hour or so, and during that time, hopefully you'll learn a couple of things. We'll cover some general contract information, and if you have any questions, please let us know either during the seminar or after. Feel free to reach out to me or someone in my office. As an aside, related to medical this morning, I found out with an appointment earlier this morning that I have severely torn a rotator cuff and now have to have surgery. I have to cancel a spring trip that I was going to take. So I'm a little bit bummed. I'm a little bit off after that information that I received this morning. So if anybody is in that industry, you have any recommendations of things I might pursue right now, I'm told. Torn rotator on my left shoulder. Anyway, let's move on with the seminar. Again, thank you for joining us. So an overview of what we're going to cover. We're going to do a little bit of contract architecture, what you see generally when you look at a contract. That'll give you an idea how to negotiate, or rather how to navigate through that contract, pick out certain points that we believe are important, whether you negotiate them or not. Sometimes there's important points that you really just need to know, even if they're not subject to negotiation, and hopefully this will tell you how to find those. And then we'll talk about 5 provisions. We'll come back. We're going to hit those throughout the next few minutes and then talk about those 5 provisions. If we have time, I'll throw in some bonus provisions and things at the end that you can also take a look at when negotiating contracts in the medical industry and maybe outside as well. And again, if you have any questions, we'll have time for those at the end, and we can also take them during the seminar. All right, so initial considerations as you prepare to enter into any contract negotiation, and these are sort of the things that I'll tell clients, generally speaking, as we begin to negotiate. We're looking at deal terms, which are the business terms, and then legal terms. But before we get into what the actual contract says, things to keep in mind as overarching principles. First thing, the intent of the parties means something. Oftentimes, if a deal goes bad and parties end up in a dispute, one of the things you will hear lawyers argue or lawyers take a position on is what is the intent of the contract, what is the intent of the parties, what were the parties' reasonable expectations. All contracts, particularly here in Florida, and as far as I know, across jurisdictions, I've practiced in other jurisdictions as well. I'm licensed in Nevada and have handled legal matters in various parts of the country. And there is an element of good faith and fair dealing that permeates all of contract law. And in fact, there are claims for not only for breach of contract, but also legal claims that can be made for the breach of good faith and fair dealing in connection with contract law. So the first thing is, when you're putting together a contract, make sure you state the intent, understand what the intent of the parties is, understand what the general expectations of your counterparty, what those are, and make sure they're in the contract and they're covered and they're clear and everybody understands it. I'm a big fan as well of using examples when those examples will help in a contract. You see this a lot, for instance, with productivity formulas and bonus formulas. I like to use examples, maybe examples on how to resolve disputes if you have a unique dispute resolution mechanism. So first thing is understanding the overarching policies behind contracts. Illegal contracts are unenforceable, and the contract must comply with public policy. Also understand who the parties and the players are. If you are negotiating, for instance, with a group for a position of employment, if you're a new position and you're negotiating an employment contract, understand that if an attorney hands you a contract, that attorney, unless you have retained that attorney to represent you, that attorney doesn't represent you. The attorney owes a duty of loyalty to his client or his or her client, and the attorney should make clear who they represent and who they do not represent in a transaction, but we don't always see that. In our practice, when we draft agreements, particularly where somebody is not represented on the other side, we have a bolded provision right at the bottom by the signature block that states that our firm represents a particular party and does not represent the other party, so there's no misunderstanding there. But you need to understand that. I see that sometimes. You see it particularly, not so much in employment agreements, it's a little bit clearer in those circumstances, but when, for instance, maybe a physician is joining a practice and is presented with maybe a shareholder agreement or some type of partner agreement that has been prepared by the practice's attorney, you need to understand that the practice's attorney does not represent you. It would be a conflict of interest for the attorney to represent two different parties in a transaction. And usually it's an unwaivable conflict. In certain circumstances, when you're representing more than one party, conflicts may be waived if the parties' interests are aligned. This would be, for instance, where two physicians are teaming up to form a business to operate a practice, and they go hire an attorney. There may be a waivable conflict there, but you still need to understand that the attorney's duty is to his client and his client only. Leverage influences strategy. Not only when you figure out what points are your deal breakers, what you cannot live with and what you cannot live without in an agreement, less leverage is going to give you less ability to modify an agreement from a position where the other side says we don't change our contracts. You'll see this oftentimes with larger employers and hospital groups, to the other side where you have somebody who's in a particularly in-demand, high-demand specialty that has a lot of ability to negotiate, particularly if they have an established practice and an established reputation in the industry. Also, in the drafting of a contract, you'll hear different philosophies from different attorneys. But in my view, considering that there is a general principle that issues not covered will go back to this first principle, intent of the parties, and whenever there's an ambiguity in a contract that is typically going to be interpreted against the drafter of the contract, I had the ability to make it clear. If I'm representing somebody who is not coming from a position of strong leverage in the negotiations, I will oftentimes look at an ambiguity and consider whether or not it makes sense to clarify that ambiguity now, or with knowledge with my client as a strategic measure, leave the ambiguity as it is and treat that as more favorable as an interpretation for my client later. So just understand that there's a strategy component to that. And understanding the deal, of course, again, the business terms and the legal terms. And when you're entering into a negotiation, we typically recommend, find a couple points that you really, that are most important to you. Also identify your throwaway points and don't necessarily throw those away. You could sometimes use things that are not important to you to gain concessions from the other side. I also like to say that parties should typically have the intent down, have the business purpose for an agreement, and have their deal terms done as we start to draft the agreement and consider legal terms. And if you find yourself trading business terms for legal concessions and vice versa, again, you should question why, and your attorney should bring that to your attention. And then finally, when negotiating, be tough but fair and civil. You can negotiate. I've rarely seen deals fall apart because people negotiate hard, as long as it's in a civil and a fair manner, and you can explain with some rational basis your position. And you'll have to, a good negotiation is both sides making some concessions in some areas. But you rarely, again, have I seen a deal where a party walks away from a bad deal and regrets it. And I've often seen clients who enter into a bad deal and do regret it. So you rarely regret the ones that you pass on because you couldn't get the deal terms right. So keep that in mind during your negotiations. And if you really can't live with something, then don't concede. All right, first part of a contract, generally, and we're going to break it up into 5 pieces. And the first part's the preface. It's that opening paragraph or couple paragraphs where it states who the parties are, what the effective date of the contract is. And it's essentially the who, what, when, and why. Sometimes you'll have a few whereas clauses that again state the purpose of the contract. The parties met, the parties decided they wanted to do this, and now below are the terms and conditions under which they're going to do it. When you're entering into a contract for parties, if you are entering into a business arrangement, you should oftentimes be doing that through an entity. And if you are entering into a business relationship with an entity, with a PA or an LLC or a corporation, check online and make sure that the parties entering the contract, including the entity through which you're entering the contract, is a validly formed entity. If not, you could subject parties to personal liability for an invalid entity. There could be other ramifications as well. It could be a red flag. One big mistake that I had a client make a few years ago, we ended up in a long bout of litigation for a few years that ended up going to trial. It ended up resolving well for my client, but it was a long journey through getting it resolved over three years of litigation fighting. Was where an orthodontist client of mine entered into a contract and entered into a purchase agreement for real estate. It was a lease with a purchase option, actually, and they were able to purchase the property and an option later, and did it through his practice business rather than creating a separate entity. So the parties are important in the contract terms. The effective date, and this is one of the 5 points that I note, as you'll see it here in red, number 1, as points that are sometimes overlooked, is the importance of the effective date. I tell clients, stick that date on your calendar, and that is the date by which generally all other dates in the contract, including your term and termination date, are going to be calculated. So if you have a contract, for instance, you'll see provisions that provide for auto renewal within every year, or contracts that provide for a termination after a year unless the parties give notice within a certain amount of time. Whatever that provision is, you need to understand it, you need to calendar it. So if you have a contract that says you're going to renew automatically every year unless a party gives notice not to renew at least 30 days prior, you want to make sure you make a calendar note probably 60 days out from that termination date, and again on your 30 days out, to take a look at the contract again, decide if you want to renew or terminate. If you don't have to do anything, then you let it go. If you want to terminate, then obviously you need to give that proper notice. And if you want to renegotiate, that's your opportunity to do that as well. So keep in mind what the effective date is. Everybody has an electronic calendar nowadays. Put that on your calendar and put it down as an anniversary date. All right, second provision here is the duties and obligations. And this is, again, this is the business, oftentimes the business terms. What are the parties doing? Why are they getting into the deal? and what are their respective duties and obligations. And an important point that I want you to understand here is the restrictions or your ability to engage in outside activities. If you are entering into a practice and you have agreed that your sole time and effort will be devoted to the practice and the practice only, that's going to take you potentially out of the ability to enter into arrangements to help, maybe to be an expert witness, to get paid consulting fees for writing or for speaking. I had one circumstance where a client contacted me and they wanted to go in with a couple of partners to develop an app. It was a medical related app, and it turns out that the contract that they had provided that any intellectual property that was developed during their course of employment, their employer had ownership rights to that property, arguably. Sometimes you can't get those provisions taken out completely, but one thing you could do is certainly at least identify that provision and maybe negotiate it. For instance, on something like that, you might try to taper that provision back to at least specify that intellectual property developed during your course of employment might give your employer rights, but intellectual property developed entirely outside of employment, your employer doesn't have any rights to. Another way to handle that, even if you already have a contract with that provision in it, and I'm seeing this again, I've been contacted a couple times over the past several months about folks developing, having ideas for software, for apps, some type of technological application for healthcare. And if you have that situation arise, rather than putting in the time and the effort and maybe the expense and partnering up with other people and then having later something be developed that your employer lays claim to, a better way to handle that might be instead to go to the employer ahead of time, let them know that you're planning on doing something that's totally outside the scope of employment. It's not going to take away from your duties or your ability to perform your duties under your contract, but you do want to work on something outside and get their written approval to do that. And if they won't give you the written approval to do that, then again, come back to what's your termination date? What are your potential outs in the contract? Is there a way to renegotiate that? Is it time to make a move somewhere else? Or at least don't put your time and effort into developing some type of intellectual property that the employer is going to make a claim to. Pardon me here. All right, let's take a look at our third part of the contract, defined terms and incorporated terms. And the big point here is don't assume you know what a term means. I'm going to come back to another example where I represented a medical provider who had a real estate contract that one of the major provisions of the real estate contract was a credit for certain circumstances for leasehold improvements. What's the definition of leasehold improvements? It wasn't entirely obvious. Understand that when you sign a contract, almost always that contract's going to have defined terms. Those defined terms might be called out through underline and bold print and put in quotes. There may be a separate section in the agreement that has specific defined terms and specific definitions. And those terms are going to be unique to specifically that contract. And you need to understand that. So if you're reading a contract and you see something, for instance, even something as simple as compensation, you may have multiple forms of compensation in an agreement, or set-offs, or operating expenses. Specific way that those terms are defined, and usually you'll see that again if a term is capitalized. If you come across and you're reading a contract that it refers to expenses and expenses is capitalized, that should cue something in your head that says, hey, why is this capitalized? It's a defined term. Ideally, again, it'll be easy to find. This is where it can be very advantageous to have contracts that you're reviewing have an electronic copy so that you can scan very quickly through the document to find that term and find what the definition is. That's what I use for contracts 30 or more pages where you have to find a defined term. When I draft contracts, I prefer that those be very clear, and I will oftentimes use a specific definitions section. Again, I like to put that right at the front, right after the whereas provisions, so that the parties know there are specific defined terms in this contract, and it sort of acts as a little glossary for the contract. Another point that I want to make here is with incorporated terms and incorporated documents. If, for instance, you sign, you're looking at a medical director agreement, and that medical director agreement incorporates staff bylaws, you need to take a look at what those bylaws say. Make sure at least that you're familiar with them. You're probably not going to be able to change them, but you need to know what they say. And you also need to understand how those specific documents can be amended or changed. So you may sign a contract, for instance, that says the document can only be amended or modified by a written amendment signed by the parties. But if you've incorporated another document, such as, again, bylaws or a code of conduct, and that code of conduct can be changed in some other way, you need to understand that. Typically, those documents will be subject to amendment by whatever the governing law is. You see this oftentimes, for instance, with confidentiality agreements and business associate agreements, where if the law changes or if there's different requirements or different standards, those will automatically be wrapped in and update that document. But don't assume that you understand what a document says, and by all means, if you see an incorporated document or terms incorporated into a document, for instance, you may see fair market value takes on the meaning that it has in the statute, or some other term that takes on a meaning in another document. Go ahead and pull that document and make sure you have a full contract. All right, boilerplate terms, and this is a favorite for lawyers, me in particular. I like this. A lot of folks assume that boilerplate is all the same. Boilerplate's not negotiable. It's unimportant. It's not worthy of the time to negotiate, and you can just pull these off the internet and everybody can use the same boilerplate terms. In fact, that's partly true and partly untrue. Some boilerplate terms are, you see them in almost every contract of the same type. And oftentimes we don't negotiate those terms, but you still need to understand what they say. A favorite of mine here is the notice provisions. In all of the miscellaneous or boilerplate or in the legal terms of a document, you'll see a mechanism by which the parties give notice, and that notice will be capitalized. And then throughout the document, again, you'll often see you have to give notice of something occurring, notice of termination, notice of renewal, notice of your intent to do something, and that notice or notify is going to be capitalized. You need to give notice according to the notice provisions in the contract. Rarely is that negotiated, but it's very important. So many times throughout the years, I have seen clients where I've asked, did you let the other side know this? And they say yes, and I say, okay, do you have a copy of whatever you notice you sent them? And they say, well, I did it in a phone call, or I did it in a meeting, and they didn't confirm. Even if you have a meeting, even if you have a phone call, if you have a notice provision in a contract that calls for a writing to be done in notice, follow up and say, okay, I'm just giving you written confirmation that I provided you notice by phone on this date, and this writing follows that up. Often now in this day of email, people typically communicate by email. Now people are even communicating by text more often. I don't have a problem with email notice, but if I have a notice provision in a contract, I'm going to have some language in there that doesn't make just email notice sufficient, or even email notice with a return receipt sufficient, because email can often get held up in spam. It can get put into separate folders. Instead, what I want is email notice with a return reply email from the counterparty acknowledging receipt of the email. Some other provisions to take a look at here in your boilerplate, your dispute resolution provisions. I'm a big fan of alternative dispute resolution mechanisms, including mediations between the parties if there is a dispute, or having the parties meet before filing a lawsuit. You can have the parties meet, do a formal mediation with a third-party mediator, and then have a cooling off period before advancing into further dispute resolution mechanisms. Some folks are fans of arbitration provisions. I think they need to be analyzed on a case-by-case basis. So I won't say that they're always good or always bad. It just depends on the circumstances. Other provisions with regard to dispute resolution, your governing law, jurisdiction, and venue. Governing law is these are often confused by non-lawyers, but governing law is going to be the law that applies to a particular document, and it usually referring to state law, sometimes federal law, but often governing law is used to identify state law. So Florida could be the governing law. If you're entering into a contract in Florida, it should be under Florida law. But if you're entering into a contract with a national company, particularly if they have their headquarters, if they're located somewhere else, I see parties enter into contracts, and that contract's subject to New Jersey law or California law. And if the contract is subject to another state's law, you need to at least acknowledge that and understand that that law may be different in your home state. And it should at least, maybe make a light bulb go off. Sometimes it makes no difference. For some provisions in a contract, they're going to be interpreted the same across jurisdictions. But other provisions, for instance, non-competes, will be enforced dramatically different in Florida than they will in New Jersey or Massachusetts. In Massachusetts, the last I looked at the law up there, I'm not licensed in Massachusetts, but they were moving towards a what's known as a garden provision, where in order to enforce a non-compete as an employer, you would have to pay the employee for the time that they are not working for you and also not competing, some percentage of their salary. Florida enforces non-competes, but other states don't always do that. Venue and jurisdiction are also important. Venue is where disputes are going to be resolved. I'm working with a client right now, and for who knows what reason, they're in a dispute with a contract counterparty that's out of state, and the dispute resolution provisions have venue in Connecticut. So now my client is faced with this situation of potentially having to go to Connecticut to resolve a dispute, and that's just crazy. So at least look at those and understand what they say. Even if you're not going to negotiate them, you want to have an idea of what's in that portion of your contract. Integration waiver, I'll touch on integration here. An integration clause is the clause in a contract that says that this agreement embodies the full agreement of the parties. That's important because if you have negotiations, or if you have a term sheet, or if you have an email where some additional terms are agreed to, if you don't have those terms incorporated into your agreement, they're not part of your agreement. That's what that integration clause does, is it keeps out things that aren't incorporated into or made a part of the agreement. Simple way to resolve that is just take a term sheet and staple it as an attachment to the contract and put a note that the terms attached as attachment 1 or exhibit A are hereby incorporated into the contract. Very easy way to deal with that. And if your counterparty is not willing to do that, then you have to question whether or not those terms are really going to be of any value later. All right, moving on, the final of the 5 pieces of contract architecture. I put these out separately, even though sometimes you find them in other areas of the contract, are your term, termination, default, and cure. Term is the length of the contract. How long does it run from the effective date? And if you have a contract that's a 1-year contract, but it allows earlier termination, and termination is obvious. Termination is the provisions under which a contract can be ended or terminated. So if either party can give notice within 30 days, 60 days, 90 days, what have you, to terminate a contract without clause, you don't really have a 1-year contract. You have a contract for whatever that provision is. Oftentimes the termination without cause provisions can be negotiated with respect to time. They should be even for both sides. If the other side can terminate without cause or terminate for convenience on 60 days, you want to be able to terminate. If you're entering into an agreement that provides for post-termination restrictions, such as an employment agreement with a restrictive covenant and a non-compete clause, perhaps you want to have that treated differently or not enforced or waived or shortened if the other party terminates without cause. So you'll have termination provisions. Those can be with cause, without cause, for immediate termination, and you'll have the term, which is the length of the contract. And then default and cure, and this is my 5th of the points that's often overlooked, is an opportunity to cure. So you'll see in a contract sometimes it'll say you can that if there's a default under the contract, the party has to give notice, and the other side has maybe 30 days or 15 days, whatever it is, to cure. What you want to add here, and I try to add this to every contract that I look at, is you want to have a provision that says that if the default is a technical default of the nature that cannot be cured within the time frame, but the other party subject to the default is making efforts to cure and doing so diligently, the cure period is extended. Here's an example that'll explain this a little better. Let's say that you have a particular credential that is required by your terms of your agreement, and that credential is renewed annually, and for whatever reason the credential lapses, and you get notice that you're now in default because the credential lapses. You fill out the paperwork, you've done everything you need to do to have the credential renew, but it's at least a 30-day process for that credential to renew, and you've only got 15 days of a cure period. Well, you don't want to be defaulted under a contract for something that innocuous. So you want an opportunity to cure defaults that can't be cured within the strict timelines of the cure provision. So as a summary, we went through full contract architecture in about a half hour. Again, I appreciate that you joined me today. Thank you. And during that time, I called out 5 specific provisions that I often see treated as unimportant or overlooked in medical agreements. And some of these apply to other agreements. The big one for medical is number 2, the moonlighting and outside business interests, intellectual property rights, etc. But you have your effective date, you have number 2, outside interests, your defined terms, understanding what those are, making sure you understand incorporated terms from other documents, your notice provisions, understanding what those are, even if you don't negotiate them, and then extending your opportunity to cure your defaults. And with that, we have wrapped up our first session of the first 30 minutes consultation that we will do every month. If you have ideas that you would like me to cover in future months, next month, I think we've already got it listed out. The following month, we're looking at potentially looking at agreements to join a medical practice. We'll look at separation provisions down the line. We may look at some security and privacy issues a few months from now. I think we're going to touch on medical marijuana in a few months. So each month we'll do something different, and I hope you're able to join us. And thank you. And if there's any questions, if there's no questions, then I guess we'll sign off today. And if you do have a question and I didn't cover it during the seminar and you didn't get a chance to ask it, please shoot me an email, bowman@fbl-law.com, or give me a call here in the office and I'll be happy to talk to you about it. Thank you very much and have a great rest of your day. Bye-bye.